Okay, so this is our presentation on long-term care planning and asset protection. So let's talk a little bit about the statistics for long-term care planning. And this is really a lot of facts and figures about the aging population here in the United States. We're getting older, and especially if you're in Pennsylvania, we realize we're getting a lot older. We have one of the older populations in the country. So an estimated 70% of people currently turning 65 are going to need long-term care in their lifetime. And they're going to receive that care probably for about 3 years. I think I may have advanced a little bit too far here. Let me go back. More than 54 million adults age 65 and older who live in the United States today. They're about 16.5% of the nation's population. But by 2050, that's going to rise to 85.7 million. So we have quite a few older adults, and they're only going to be getting older, right? This baby boom generation is going to continue to age into the area where they're going to need a lot of long-term care. 1 in 6 people in the United States is an older American. That's 65 and older. And so the demand for elder care is going to be driven by a steep rise in the number of Americans who not only are getting older and aging into that area where they are going to need some extra care to take care of daily living, but also the increased incidence of folks who have Alzheimer's or dementia, some type of a cognitive deficit that make it difficult for them to continue to live on their own without some kind of assistance. 18% of seniors are going to require more than 1 year in a nursing facility. And a nursing facility is a type of long-term care. It's part of the long-term care continuum. We'll talk about what is in that continuum. But nursing care is for folks who are physically or cognitively very needy, that need a lot of help. Life expectancy continues to increase. Prior to COVID, which knocked the statistic down a little bit, life expectancy had reached an all-time high of 79 years old. But that's a good thing. Typically, that's a good thing. But every good thing comes with something on the other side to sort of balance it out. And in this particular instance, the longer we live puts us more at risk for outliving our savings, right? And paying for elder care could be difficult if we don't do some planning in advance, or we won't be able to leave a legacy for our children. Whenever I talk to people about long-term care, they're very, very concerned about the expense of long-term care. And if you spend any time at all investigating long-term care, you realize how expensive it is. And let's talk a little bit about that. And these are Pennsylvania average costs of long-term care. It does vary from state to state, but these are a pretty good barometer for what long-term care is going to cost, no matter where you're dialing in from. Whether it's Pennsylvania or Ohio or California or wherever it is in the country. Thank you for joining us. And this is a good barometer. So a private nursing home bed, nursing home, not personal care, not assisted living, not independent living, but nursing care. The highest level of care that somebody would need is provided by a nursing facility. That's going to cost a little over $10,000 a month and $120,000 a year. So it's very, very expensive. All of the nursing costs and the regulations and the safety precautions and the things that apply to nursing facilities makes the cost of care very expensive. A semi-private room, which most people don't want in this time and age, is going to be a little bit less expensive, but not a lot less expensive. Let me see, we have a couple of people that want to be admitted. A room in an assisted living facility, which is a step down from nursing care, is going to run you about $3,500 a month. or about $43,000 a year. And if you're lucky enough to be able to stay in your home, but you need somebody to come in, provide some type of a caregiver, basic caregiving in your home, that's actually going to be more expensive than being in an assisted living facility, primarily because it's a 1-to-1 ratio of care, whereas an assisted living facility is definitely not 1-to-1 ratio of care to patient. So actually bringing somebody in your home to take care of you or a loved one is pretty expensive. So let's talk about the types of long-term care. And we've got home care, and there's two different types. There's private duty, which is a caregiver who is there to provide some basic care, cooking, cleaning, maybe help getting dressed, those types of things. Let's see here. But that's what they do. It's not nursing. It's not skilled nursing. But then we have professional duty care, which is going to be a little bit more skilled nursing. You don't typically have somebody come into your home and stay there with you for extended periods of time if they're professional duty nursing care. That's somebody that comes in on an episodic basis to provide wound care or some other types of highly specialized medical care. But so you have care that happens in your home. We have independent living. Typically, independent living is part of a continuing care retirement community. And really, independent living just means it's an apartment. You're living on your own, you have a kitchen, you're cooking for yourself. These facilities will typically offer you some type of a dining option. If you don't want to cook for yourself or you can't cook for yourself, they're going to provide something like that, but it's basically independent living. There's nobody coming into the home, nobody available to come in to help you get from bedroom to bathroom or do those types of things. Assisted living and personal care, at least in Pennsylvania, are essentially the same thing. And there are some differences in from a regulatory standpoint, but by and large, they are the same thing. And so these are for people who need some assistance with daily living, but folks that are in personal care or assisted living are typically able to get themselves up, get themselves dressed, move around the room, leave their room, walk, ambulate, do those types of things. It's just that they need some extra help with daily living. You're not going to have a kitchen in your room, most likely. You're going to be eating in a dining facility of some kind, typically, but then there's more assistance available to you with aides and other types of professionals that can come in and assist with things that you need. Nursing care is really the highest level of care. And nursing care is typically for folks who really can't get themselves from one spot to another without some type of assistance. So they can't get up out of a chair by themselves. They can't get themselves from a chair to another location in the room, such as the bathroom. They won't be able to get in and out of the shower by themselves. That perhaps they have serious cognitive deficits where they're not oriented all of the time. That's what nursing care is. It's really the highest level of care that's available to somebody in a facility setting. Continuing care retirement communities are communities that offer a variety of these levels. And so a full CCRC would have independent living, it would have assisted or personal care, and it would also have skilled nursing care available so that you can, once you enter in independent living, as your needs change, that your need for care changes, they can move you in the community, probably to a different room or a different setting, but you're in the same community. And so you don't have to find a new place to go and live and get that care. You can just move from one room, in essence, in one building to a room in a different building, but all under the same broader caregiving roof. And then hospice care is end-of-life care. That can happen either in a facility or at home. And hospice care is palliative care, meaning you've got an end-stage medical condition. Medical treatment is no longer going to make you better. It's not going to cure you of whatever your ailment is. And this hospice is there to provide comfort, to keep you comfortable as that health situation progresses, and you're sort of in the stage of dying, or your family's in the stage of dying. It can be a very, you don't want to be in hospice care, but if you have to, folks that go into hospice care or they have family members that go into hospice care realize what a blessing it can be whenever their loved ones can be made comfortable. So the big question is, how do you pay for long-term care? And there are a variety of ways that long-term care is paid for. And when I say long-term care, at least in this particular instance, what I'm talking about is home care, personal care, assisted living, these types of things. This is what I would refer to as long-term care. And you pay for it either with private pay, meaning just out of your pocket. There are veterans benefits that can be available for wartime veterans who have had at least a short period of time in service during wartime. And then you can also purchase long-term care insurance from a wide variety of insurance companies to help pay for those types of care: personal care, assisted living, home care. Depends on what you buy. There are lots of different products available out there. Now, who pays for nursing care? Skilled nursing, the type of care that's the most expensive type of care that you can possibly get. Well, we're going to talk about Medicare and we're going to talk about Medicaid. They sound very similar, but they're very different. So first we'll talk about Medicare. So Medicare pays for a very short period of time, and it's usually following a hospital stay. You have to have had a hospital stay for 3 days. I should probably put an asterisk behind that, because not every hospital stay is a qualifying medical stay for Medicare eligibility. It really depends on how you're classified whenever you're in the hospital. Sometimes you can be admitted for observation only, and that doesn't start the clock ticking for your 3-day hospital stay to qualify for Medicare benefits. If you're admitted to a Medicare certified nursing facility within 30 days of that hospital stay, then Medicare may be available to pay for that care. And it has to be a Medicare certified nursing facility. Not all of them are. Most of them are, but not all of them are. Typically, this is going to be an admission to a short-term skilled nursing facility. Maybe you've had hip replacement surgery or a knee replacement surgery or some other type of an injury where you've cracked a bone that makes it very difficult for you to get around, and you're going through the healing process. That would be a situation where you'd be admitted to a short-term rehab facility that's skilled nursing, provides skilled nursing, and Medicare would be available to pay for that, in addition to your health insurance if you have health insurance. So if you need skilled care, and that's going to be something that your doctor will have to certify, then Medicare can be available. It pays for all or a portion of your expenses for up to 100 days. And so the first 20 days are going to be covered at 100%, and then it scales down after that. So even though Medicare will pay for your care for 100 days, it isn't going to pay for all of your care for that period of time. Something to be cognizant of. Who else pays for nursing care? There are other sources of payment. Again, you can have long-term care insurance to pay for nursing care. Long-term care insurance, not a lot of people have it. It is expensive. It does have limitations. It just depends on the type of product that you buy. You may purchase long-term care insurance that provides a maximum daily rate that doesn't cover all of the expense, or you might buy a policy that only kicks in after a certain period of time, or will only pay for a certain period of time. So there are all different types of products that are available out there. So you really have to do your homework whenever you're shopping for that. Veterans benefits, again, are available. Private pay, you always pay out of your pocket. Every facility is very happy to take your money out of your bank account. But then also Medicaid is available to pay for nursing care in some circumstances. So let's talk about what the difference is between Medicaid and Medicare. So Medicaid is a state and federal program that provides medical and long-term care benefits for people who meet a means-tested standard, meaning there is an economic eligibility component to it. You can't have more than a certain amount of income or assets that are over a certain value. That's what the Medicaid eligibility requirement is. It is for the financially needy. Medicare is a federal program that pays for medical and hospital care for people who are over age 65 in most instances, who pay for a monthly premium. Medicare will not pay for long-term care beyond that 100 days that we talked about after a qualifying hospital stay. Medicaid does not pay for long-term care for aged, blind, and disabled persons it does pay for the long-term care expenses for aged, blind, and disabled persons who meet the eligibility requirements. If you do qualify for Medicaid to cover your long-term care expenses, the Medicaid recipient is going to pay all of their monthly income in most instances to the facility. There are some exceptions to that. And then Medicaid will pick up the balance of whatever it is that they will pay to the facility. It's not going to be 100% pay. The facilities will have to accept a lower reimbursement rate, but the Medicaid will pick up the tab for the balance of whatever it is that they're willing to pay. Now, really important thing to remember here. Excuse me. Not all nursing homes accept Medicaid, right? Don't be fooled into thinking that any nursing home is going to accept somebody that is eligible for Medicaid. Nursing homes have to be licensed and certified by the state as a Medicaid nursing facility. And not all nursing homes are Medicaid licensed. So if you are in the market to shop for a nursing facility, that's the first question that you should really ask. Very important question to ask. Just because a facility has beds available does not mean that they're going to accept a new resident who is eligible for Medicaid. So even if the facility is licensed to get paid by Medicaid for the long-term care services that they're providing to their patients, that doesn't mean they're necessarily going to accept somebody who is eligible for Medicaid. And many licensed nursing homes make a limited number of beds available for Medicaid eligible residents. And so some facilities will be licensed for 30 Medicaid beds. That's the term of art that's used to refer to it, right? They can have up to 30 people in beds that Medicaid is paying for, but some facilities might only make about 6 or 8 of those beds available for folks that are on Medicaid. Some facilities have a much larger percentage of their maximum number of medical assistance beds available to patients, and some have less. It just depends. Some facilities will not accept new patients who are Medicaid eligible from day one. It just depends. A lot of the nicer facilities are going to shy away from folks who can't private pay for a while or don't have some means of paying other than medical assistance. Really, for them, medical assistance is only there to help cover expenses for the residents that have already been in there in private paying who have run out of money. Now, if you have any questions as we go along the way, and I would certainly imagine that you do, if you don't, I would be highly surprised. Please drop them into the chat I will answer as many questions as you have to the extent that I'm able at the end of our webinar. So please don't be shy. Drop questions into the chat, and I will take a look at them at the end. So let's talk about the financial eligibility requirements for Medicaid, long-term care medical assistance. So you can qualify in a couple of different ways, but the long and the short is that you have to be financially needy and medically needy, right? So you have to need nursing care. You have to be certified to need nursing care. And you can't just be an able-bodied person or somebody that would otherwise be moving into a personal care facility, but move into nursing care. You probably wouldn't want to do that, but you have to be medically needy. But you also have to be economically needy too. And so I've provided an example here where your income, if it's under $2,400 gross monthly income, there's going to be an income and eligibility, income and asset component to it. But you have to have $8,000 or less of resources, assets in your name. If your income is under about $2,400 a month, your gross income, then you can have assets of $8,000 or less and qualify for medical assistance. If you are over that gross monthly income, then the resource allowance, meaning the assets that you can have and be eligible, is maxed out at $2,400. It's very, very small amount of money, very small amount of money. But not all of your assets count for purposes of Medicaid eligibility. Countable assets include jointly or solely held assets. So even if you're a husband and wife, jointly held assets are going to count for purposes of Medicaid eligibility. Cash and money in bank accounts like checkings and savings accounts, these count for purposes of eligibility. Investment accounts that you would have, so stock accounts, mutual fund accounts, certificates of deposit, if people have those anymore, money market accounts, bonds of whatever kind that you have. All of those are assets that count for determining whether you're eligible for medical assistance. Your retirement accounts can count as well. Annuities, life insurance, cash value can also be an asset that counts for purposes of eligibility. Just the cash value, not the death value, but the cash value. Real estate that is not your primary residence is a countable asset. A second or additional vehicles. Assets in irrevocable trusts. So not all trusts are going to protect your assets for purposes of medical assistance. So if you have a revocable trust and you're using that as your estate planning vehicle and your assets are titled to the trust, those are viewed as your own assets, as if they were titled in your name for Medicaid eligibility. And basically any type of an asset that you have control over is going to be considered a countable asset by and large for purposes of qualifying. Now, not all assets count. Some of them are exempt. And so these are just not taken into consideration whenever determining if you're eligible. Your primary residence, right? Unless it's over a significant amount of money, maybe that's a little bit more likely these days since real estate values have gone up significantly as a result of the COVID pandemic, but primary residence typically doesn't count. One vehicle, doesn't matter how much it's worth, could be a Rolls Royce. One vehicle doesn't count. Household goods, personal belongings, I've never seen the department look at those at all. Life insurance with a face value of less than $1,500 doesn't count. That's really kind of small. Term life insurance, which typically has no cash value component to it. So even if it's $1 million death benefit, it's irrelevant for your application. Property that is essential for self-support. So if you have income producing property, that can sometimes be excluded or exempted from the eligibility analysis. Burial plots and markers don't count. If you have money in an irrevocable burial reserve, so maybe you've prepaid for your funeral expenses, there are some life insurance products that are available out there that serve as an irrevocable burial reserve, that you've got money in there that is earmarked to pay for your burial. That doesn't count. And that amount goes up every year, and the amount in particular depends on where you live. It's sort of based loosely upon what the average expenses of a funeral are in that particular county. So I'm in Allegheny County, that's where Pittsburgh is. And for at least for 2021, the allowable amount that you could have stashed away is $22,000. So that is not looked at, but it has to be in a qualified burial reserve. It just can't be $22,000 of cash in a bank account that you've personally earmarked to pay for your funeral. Qualified assets of the community spouse. And so these would be retirement type assets that the community spouse, meaning if you're married, the person that isn't moving into skilled nursing, but is still living in the marital home, those assets are not going to count. This would include an IRA, 401k, 403b, those types of accounts. And then your spouse that's not moving into the facility also can protect what's called a community spouse resource allowance, which is an amount of money not less than $26,000 and not more than about $130,000. They can shield that money. They can protect it from eligibility. So that's really there so that they can support themselves in light of the fact that one of the spouses is going to be moving into a facility. A very common situation, husband or wife has a stroke, and they can't live at home anymore because the stroke renders them very disabled, and they have to move into a facility full time. That can be a very devastating situation financially for that couple, especially for the spouse that's remaining at home and continuing to live at home, and now has to bear all of the expenses of their lifestyle with a single income. And maybe it's not the supporting income. So that can be very difficult. That's why this community resource allowance is available out there. So for going on with Medicaid for married couples, the spouse that lives in the facility is typically called the institutionalized spouse. That's just the term of art. It's unfortunate. It doesn't sound very nice, but that's typically what it's referred to. But the person that's living in the facility is the institutionalized spouse, and then the other is the community spouse. So they could be living at home, they could be living in a personal care home somewhere, or anywhere, basically, just not living in the nursing home. That's what the community spouse means. So the spousal resources, let's talk a little bit about that. And again, we're talking about the one that is not living in the nursing facility. So at the time, let's take an example of a couple, husband and wife. Husband had a stroke, and he's now having to move into a nursing facility, can't live at home. Wife is unable to care for him for whatever reason. So at that time, a resource assessment is completed. That's literally a form that the facility is going to fill out, and they're going to take a snapshot of the couple's countable assets, meaning assets that are countable for purposes of Medicaid eligibility. The spouse that continues to live at home, let's just say in our example, is going to receive the community spouse resource allowance. And as I had mentioned, it's not less than $26,000, not more than about $130,000. And that also changes on an annualized basis. The spouse moving into the facility keeps whatever their resource allowance is, either $2,400 if their income is below that, is above that $2,400 a month threshold, or $8,000 if it's below the $2,400 a month threshold of income. If they have extra money left over, all of that money must be spent down or do a smart spend in order for them to then be eligible for medical assistance. So here's a couple examples, very simple examples of how this might work. So in example one, the countable assets of the couple are $34,000. Countable assets, $34,000. and the spouse moving in to the facility has a monthly income of $3,000. So in our example, let's just say the wife who's continuing to live at home, she'll get to keep $31,600. The husband moving into the facility gets to keep his $2,400 allowance, and he's immediately eligible for Medicaid. Wife gets to keep $31,600 because that's within the community spouse resource allowance minimum and maximum. So she gets to keep all of that, and it's not doesn't have to be spent down. So immediately eligible. So in example 2, we have countable assets of $250,000, and again, the monthly income of husband moving into the facility is $3,000. So the wife who's remaining at home gets to keep the full amount, the maximum amount of the community spouse resource allowance of a little over $130,000. Husband gets to keep his $2,400 allowance. And then there's excess, meaning $117,000. So they're not eligible for Medicaid, at that time. And they would have to do a spend down of that $117,000 in order to be eligible for Medicaid. Income considerations, spousal income, in our example, the husband who's in the facility, all of his income, so let's just say he has Social Security income, that's paid to the skilled nursing facility with the following exceptions. He gets a $45 a month personal needs allowance to pay for haircuts and snacks and things of that nature. Doesn't go very far. Health insurance premiums, those will continue to get paid. And it's possible that there could be a spousal allowance that is paid to the wife who's still living at home if their income is low enough. And so let's take a look at that. So this is the situation that we have whenever we've got one spouse in a facility and the other spouse living at home, and the one living at home has a very, very low income. There is what's called a minimum monthly maintenance needs allowance. And so it does allow a married Medicaid eligible applicant who's living in the nursing facility to transfer a portion of their income, or in some cases all of their monthly income, to the spouse that continues to live at home to help her support herself. So the minimum figure for that income is a little over $2,100 for that community spouse. So if it's below that, it's likely that that spouse that's living at home is going to be able to have some share of money from their spouse's income that's living in the facility paid to the one that's living at home to help provide for their needs. And so the nursing facility is just going to receive less money on a monthly basis, as a result. So let's talk a little bit about the state recovery. So the Department of Human Services, which is it's the government agency that administers the medical assistance program here in Pennsylvania, they can seek to recover whatever they've paid on behalf of somebody who is eligible for medical assistance. They can collect back, they have a claim on that Medicaid recipient's probate estate for the benefits that they received. So applying for Medicaid and qualifying for Medicaid does come with that caveat that if you leave a probate estate, the state is going to claw some of that money back. But it's limited to probate assets. Very important thing to understand what probate assets are. Probate assets are only those assets in that Medicaid recipient's name alone, which are not owned jointly with another person and are not designated to transfer to somebody else at the time of death. So your probate estate is just assets that you own in your own name. Bank account just has your name on it. A house or a piece of real estate that just has your name on it. A car just titled in your name. Those are assets that are going to be passing as a result of your probate estate, passes in accordance with your will If you don't have a will, the government has one for you, and it'll pass according to the government's will for you. Never a good idea to rely upon the government's will for you. That's a recipe for disaster for your family. So the state's claim is only against probate assets. Non-probate assets, meaning assets that would pass regardless of what your will says. Examples of those would be a joint bank account, because that contract that you sign with the bank on your joint bank account says that after you die, this is where the money goes. And it's going to go to whoever the joint account holder is in most instances. Maybe you've got a piece of property that is owned jointly with your spouse or with another person that says by right of survivorship. And so when you pass away, that property now belongs to whoever the surviving tenant is on a property that's held in that way. If you have assets that are passed by operation of a beneficiary form, very frequently IRA accounts, 401k accounts, 403b accounts, qualified annuities, they're all going to pass to somebody in accordance with a beneficiary form that you have filled out, and that is going to bypass your estate. It doesn't pass according to your will. It is not a probate asset, and the state does not have a right to recover against it for the amount of benefits that they've paid on your behalf. So those are kind of the basics of the long-term care continuum, what types of care are available out there, and then also how you pay for it, including medical assistance. It can be a pretty complicated analysis to figure all of that stuff out, but it's doable, right? If you have somebody that is going through or is going to be needing to go apply for medical assistance, I will tell you that you really should hire a qualified elder law professional to assist you with that. The facilities will help you apply for medical assistance benefits, but they don't have an obligation to help you do a smart spend, right? They don't have an obligation to help you spend any extra assets that you have on a spend down in a way that's going to benefit you or your spouse or your family member. They're just they'll very gladly have that money spent on them until they go through the entire spend down, and then and only then will you qualify. You lose the benefit of all of that money. And there are lots of different things that you can do to protect those assets from just a pure spend down on the nursing facility. So let's talk about a little bit of asset protection techniques and some planning for this possibility that you might need nursing care and that you want to qualify for medical assistance for it. And we look at this in two different ways. There's proactive planning, and then there's crisis planning. Both can work, right? But the proactive planning is obviously better, a lot more options available. Crisis planning, less options, but it can work. So proactive planning really means positioning assets in such a way that it protects you from a Medicaid spend down before you need long-term care. We take a snapshot of the assets that you have and figure out what you're going to need to live on, what you might be able to be generous with, meaning you could do some more advanced planning because it's not likely you're going to need these assets in order to live on. Crisis planning means we employ some strategies for persons that need nursing care immediately, right, or in very short order, in order to protect as many assets as we can as possible from a Medicaid spend down. Keep in mind that there is a 5-year look back on property transfers. So any assets transferred within 5 years of applying for medical assistance, the state's going to take a look at those assets, and if they are just gifts, if you're just giving the money away, they're going to claw that back, so to speak. They're not going to make you not going to make whoever has the money give it back, but they're just going to count that money as if you owned it, and will factor it into some period of ineligibility for medical assistance. So who are the crisis clients? Age 65 and up, right? Maybe 70 and up. You're getting up there where it's much more likely that you're going to have a health event that will require some type of nursing care. If you're disabled, right? If you're able to get SSI, benefits, these are the crisis clients. These are the folks that really should be doing this type of planning sooner rather than later. If you have assets or income at that age, which would prevent you from being eligible for Medicaid immediately, you should be doing some planning. We can help with folks that are in this situation. Proactive clients, age 55 and older, including children of parents who are age 55 and up, have a positive net worth, or clients with special needs, children, or spouse. These are proactive clients that really should be thinking about this and taking a look into the future, and at least understanding, what long-term care planning is, what the options are available to them, and doing some planning for it. So I see a lot of and hear and receive calls quite frequently from clients who I think want to do some type of asset protection. And there's a lot of urban legend out there, right? The very typical is somebody calling saying, I want to put my kids on my deed. And I ask them why they want to do that. And very frequently they say, well, I want to protect it from the nursing home, right? That's kind of how they say it, right? I don't want to lose my home if I ever have to go into a nursing home. And so I'm going to put my kid's name on the deed. Or maybe they'll just transfer the deed entirely to their kids so that it's out of their name entirely. And a lot of these things are based upon misunderstandings or bits and pieces of understandings about medical assistance and how to qualify and how to do some advanced planning. So let's talk a little bit about things that you should not do. These are not good ideas for medical assistance planning. Transferring assets for less than market value, fair market value in the 5 years before you apply. Now, of course, we don't always know when we're going to apply, but I have a pretty good idea that somebody that's 87 years old might need nursing assistance in the next 5 years. And so doing transfers, at that late stage in the game is always a risky thing to do. Transferring assets to children. Here's the example: putting your children's name on your deed, making a bank account jointly owned with a child, giving assets to a child. These are all things not to do straight up if your purpose is to do medical assistance planning. These are all types of transfers that, if they're done within 5 years of applying, are going to be disqualified transfers, right? Those assets are all going to be counted as if you own them, and will be factored into a period of ineligibility for medical assistance benefits. And the worst thing would be if you've given them away and you can't liquidate them or use them to pay for your care. Now you're ineligible for medical assistance. You don't have the money to pay for care. You're kind of stuck. That's a really bad situation to be in. There are a lot of other reasons a lot of other things to think about or to take into consideration before you would transfer assets to kids or put your kids' names on a deed. It's kind of a complicated thing. It seems simple, but it's a lot more complicated than it seems. And we would love to talk with you about that if you ever are thinking about doing that kind of a thing. That's like entering into a partnership with your child, and you're inviting their lives into your life. You're inviting their judgment, creditors, their financial problems into your property. You're not free to make your own decisions about your assets anymore. Maybe they get caught up in a divorce of some kind with your kids. There are lots of complicating factors. You could even end up costing your kids more in taxes by giving them property rather than passing it to them through your estate. So it's much more complicated than it seems. And you'd want to talk to an attorney that handles estate planning and real estate work before you would do something like that. So a couple of things about estate recovery. So if you have a loved one that is in a nursing facility and they're Medicaid eligible and they're receiving Medicaid benefits, there are some things that you can do after the fact to try to defeat the state's ability to take money out of that person's probate estate. So if that person has money in a bank account, make a joint with somebody. Then it passes at death, according to that joint bank account. It's no longer a probate asset. Seems kind of like dirty pool, but you can do that. Life insurance, make sure never name your estate as the beneficiary. It's the worst thing you can possibly do. So two bad things with life insurance is name your estate as the beneficiary or leave it blank. Both of those mean it's going to go to your estate. Life insurance is not subject to inheritance tax in Pennsylvania, but if you pay it into the estate, you may end up making it taxable. Plus, it's going to go through the probate process and kind of defeats the purpose of life insurance as a vehicle of passing assets to your family members quickly and without a lot of administrative burden. So make sure that you've got beneficiaries named on your life insurance policies. That's something that people tend to forget or just don't keep on top of because they're not planning on dying anytime soon. If you have a residence, it is the most recovered asset if it's in that Medicaid eligible person's name. If married, retitle it into the community spouse's name, right? Just transfer it to the spouse that's still living in the home. Now it's just not part of the Medicaid eligible recipient's estate at all. If they're unmarried, give it away, sell it, do something with it, but get rid of it, because if you die owning it, the state's going to take a bite out of it. It'd be much better off selling it or giving it away, doing something with it that you can get some benefit out of, or that your family can get some benefit out of. And although this sounds like a terrible thing to suggest, in our situation, husband and wife, husband being in the nursing home, wife being still living at home, wife should really change her will and disinherit her spouse. The last thing that we would want to have happen is the spouse living at home who has protected that community spouse resource allowance, right, passes away and leaves that money to their husband in the facility. Now they're all of a sudden ineligible for medical assistance benefits again. That money will all have to be spent down, and then they'll have to go through a reapplication process for medical assistance. That would just be an awful thing to have. So it seems mean or counterintuitive for the spouse living at home to change their will and disinherit their dependent spouse, but that's really the smart way to beat the state and prevent them from taking your hard-earned money. Now, if you recall our example with our couple that had $250,000 of countable assets, and after we did our analysis, they ended up with about $117,000 of assets they had to spend down. They can do what I would refer to as a smart spend down, where they can spend that money wisely and get some kind of benefit out of it rather than just pay it to the facility. And that's no knock on nursing facilities. They provide a very valuable service, not looking to cheat them or anything like that. But you can get some benefit out of that money or spend it down faster and hasten your eligibility for medical assistance sooner. And so things that you can spend that money on that you'll get some benefit out of is buying an irrevocable burial reserve or prepaying for funeral arrangements. No reason to not do that. You should spend the money on that, because otherwise you're just going to be spending it on the facility. You can make improvements to the residence. Right? Your spouse is going to be living there. You can spend it on the house. Get a new kitchen, renovate, buy new windows. Make that as maintenance free as you possibly can. Spend the money on your residence. You can even buy a new home if that's what you want to do. If it's just going to go to the facility, buy a new home if that's what you want to do. Convert it into something that you're going to get some kind of benefit out of that is exempt from eligibility. Buy a new car for your community spouse if you only have one car. Pay off the mortgage to reduce your monthly expenses, or a home equity line of credit. Again, make it less expensive for your community spouse to continue living. prepay real estate taxes or homeowners insurance or other types of bills. You can also purchase items for your Medicaid eligible recipient, your spouse, or even a disabled child. So these are all ideas or types of things that you can do to do a smart spend down to get the benefit out of that money that is making you ineligible for medical assistance. You can take advantage of some exempt transfers. So you can transfer assets in advance. And so this is sort of part of a medical assistance application. And this is what an elder law attorney or professional can do for you if you have a loved one or a spouse that is likely going to need to move into nursing care or who is about to go through the application process for medical assistance. A professional who does this type of planning can make sure that assets are moved around. Sometimes they need to be moved around between husband and wife in order to ensure that that spouse that's going to be living at home gets the maximum community spouse resource allowance. It's not just automatic, right? Certain types of assets aren't going to be or qualify for that community spouse resource allowance. And so you're going to do some planning to make sure that that person can get the full $130,000 of that community spouse resource allowance. Maybe you'd want to transfer the house to the spouse, in advance, or even to a child under 21 or who has special needs. These are transfers that will not disqualify you from medical assistance. If you've got a special needs child under age 65, you could take money and set up some type of a special needs trust for that child. Those again are transfers, a gift that you can make for that special needs child who's under the age 65 and transfer that money into a special needs trust for their benefit. Don't spend it on the facility, spend it on your kid, right? You can make $500 a month transfers into a bank account, give it away. Those types of small transfers don't count. And selfishly, I had to put it in there. You can pay your lawyer, right, to do this planning for you, to do a smart spend down. That is a perfectly good expense. And if you're, facing a situation where you've got, as in our example, $117,000 of money that you have to spend down, a lawyer can help you get the benefit out of the vast majority of that, right? Certainly well worth the cost of hiring a qualified elder law attorney to assist you with that. You can also look into purchasing a Medicaid eligible annuity. So this converts a countable asset. Maybe you've got that $117,000 that has to be spent down. You could convert that into a special type of an annuity. It's an immediate annuity. And so it converts this asset, this $117,000, into a stream of income that's available for either the applicant or the community spouse. So it can be very helpful for married couples when the community spouse has limited income. And it can also generate some income to pay for expenses while you're going through that period of ineligibility. And again, this isn't any annuity. This is a special type of annuity that meets special criteria that I've listed at the bottom of this slide deck here. So it's just enough to know that this is a strategy that's available that can potentially turn somebody very quickly who is ineligible for medical assistance into somebody who is eligible for medical assistance. Now, we can get into a lot of advanced strategies for asset protection and making one eligible. And I'm not going to go into great detail on these because really you have to design the strategy for the client, right? And no two clients are the same. So you really have to plan something that is customized, specialized for whatever the situation is that is presented to you. So not all of these things are going to work in every situation or be appropriate in every situation. But these are some examples of the types of advanced techniques that elder law attorneys use to help people plan in advance to shelter assets, that long-term planning client, or even in a crisis situation. But we can use irrevocable trusts to help. This is different than a revocable trust. Revocable trust means you've got control over it and you can end it anytime you want. An irrevocable trust means exactly that, that once you set it up and you fund it, you can't undo it. Now, it's a little more complicated than that, but that's the basic thing that you have to understand with an irrevocable trust is once you set it up and you fund it, basically you've made a gift that you can't take back. And it's going to be in that trust forever and a day, but it means that you don't own that money anymore. That's what that means from the government's perspective. So, but that's a tool that can be used to shelter assets. You can do some changing of beneficiaries on qualified plans to render them not countable for purposes of medical assistance. You can do a variety of gifts and give backs that are some legal shuffling, of assets that are intended to basically turn these into a stream of income rather than an asset that renders you ineligible. Personal care agreements are something that we're seeing a little bit more of these days, where we've got a medically needy parent who has moved in to somebody's home, and like a child's home, and they sign a personal care agreement, and they're going to pay them to take care of them or pay them to live in their home. So we do see these types of agreements that are signed between children and parents, where parents are living with their kids. If that's your situation, you should know that that situation may lend itself to this type of strategy for sheltering assets. That needy elderly adult can pay money to their kids, and that money it's not a gift, it's really a payment for services under this type of agreement, and that's a way of transferring assets out of your name at a much faster pace than you could otherwise in sheltering those assets. There are a variety of these advanced techniques that are available out there. So these are really things that you should talk to your elder law and estate planning attorney about. But very important, we can get all caught up in the fancy-dancy advanced techniques, but it's really a big mistake to skip the essentials, right? Very, very important for everybody to have a will or a revocable living trust. There are reasons for having one or the other. Like I said before, you want to have a will. You don't want to rely upon the government's will for you unless you think that the government knows exactly how you would care for your family. I don't think anybody would think that. And so if you don't trust the government to take care of your family and manage your hard-earned assets, then have a will. It's pretty simple to do, pretty inexpensive to do, and it's a smart thing to do. So have a will or revocable living trust as your estate planning vehicle. You absolutely positively need a durable general power of attorney. I call that a financial power of attorney, where you're nominating somebody to handle your assets for you in the event that you're unable to do so. You need to have a healthcare power of attorney too, to designate somebody to make medical decisions for you. Or if you're in an end of life health situation, you can say what happens, and either you're the decider or you nominate somebody to make those decisions for you, and maybe you give them some guidance on the types of things that you would or would not want to have if you're in an end life medical condition. You absolutely should make sure that your beneficiary forms are completed, right? So if you haven't looked at your IRA, 401k, life insurance, annuities for a long time, it's a great time to dust them off and take a look at them. And number one, make sure that they have somebody named in them, right? But more importantly, you want to have them so that they're coordinated with whatever you've put in your will or your revocable trust. You absolutely positively do not want to create a beneficiary form that could result in paying money to a person who's a minor under age 18. That's really a disaster waiting to happen. And so if you have grandkids or even kids that are under age 18, it's very important to make sure that those beneficiary forms work in concert with a trust that you have set up in your will or your revocable living trust. If you check out our YouTube channel, just Google Fiffik Law Group on YouTube, there's a video on there called Beneficiary Form Boo-Boos, where I talk about all the boo-boos that you can get yourself into by not filling out or incorrectly filling out your beneficiary forms on a wide variety of accounts. So very important for you to do that. And then you should also be thinking about your digital estate plan. There are more assets that you own in the digital world now than ever before. The average person owns 80 apps, has 80 apps on their phone. I would bet that many of you have your bank accounts that are electronic. You don't even get statements anymore. You have a lot of things stored in the cloud. Maybe all of your photographs are stored in the cloud. Maybe they're all on your phone. These types of digital assets, these are examples of digital assets that you really should give thought to as you are creating your estate plan. And we're going to talk a little bit more about that, not tonight, but in a separate webinar that I'll tell you about a little bit later. Your power of attorney should have gift-giving powers for your agent, because they might need to do some of the crisis planning that I've talked about whenever you can't do it. These are called hot powers, at least in Pennsylvania, they're called hot powers, and they must be specifically granted to your agent, your power of attorney, for purposes of Medicaid planning. So if you're in Pennsylvania and you have a power of attorney that was done before January 1st of 2015, you probably don't have a power of attorney that gives your agent the maximum ability to do medical assistance planning for you. Really important to take a look at that and get a new one done. You would give them the ability to create a lot of different types of things for you. Going a little long here, I apologize. So that's it. That's what I wanted to talk about tonight. We have a wide variety of estate planning resources available on our website. If you go to the Trust and Estate Planning section of our website, we also have a YouTube channel where we've got some videos that talk about estate planning. And we have some webinars coming up, actually. Just very briefly, a programming note. I will tell you that we have an associate workout. If you're a Legal Shield associate, you're tuning in. That's tomorrow night at 5:30 Eastern time. We also have a very special webinar on distracted driving by teens and cell phones, and that's on March 23rd at 5 o'clock Eastern Standard Time. So great thing for moms and dads to tune in and watch with their teen drivers, or like if you have a daughter, my daughter, youngest daughter is 15. Certainly I'll be having her watch that with me. We've got tax issues for small business on April 7th. That's at 3 o'clock in the afternoon Eastern time. And then we also have a digital asset planning webinar scheduled for April 13th at 6 o'clock. So let me real quickly take a look and see if I have any questions. I have some questions here. Allison asks, is the 100 days for skilled nursing an annual number or can be used, or is there another measurement to use between nursing home stays? It's going to be 100 days per stay. So it's possible that you could have 100 days, go another month, have a qualifying 3-day hospital stay, and then get another 100 days. So it is possible for that to happen. It's not necessarily an annual thing. If unmarried, can you do a beneficiary deed on your home to a family member? You can name a beneficiary, sort of an entrust for deed to a family member. Don't typically do that. You could probably just do that in your will if that's what you want to do. But if it's the only asset that you have and you want to avoid probate, certainly that would be a way to do that. You could have it jointly titled, or you can just say it's in trust for a beneficiary of some kind that gets it only after you pass away. So are there any other questions that I can answer? Feel free to unmute if you want to shout it out. Anybody? Anybody? I know that was a lot of stuff. Like I had mentioned before, it was an information dense presentation tonight. There's a lot of things to think about there. Anytime I have somebody ask me about medical assistance planning, they don't always ask it exactly that way, but I know what they're asking about. It's such a huge topic that it's difficult to talk about. It's not a 5-minute conversation. It's usually a series of conversations, because very quickly it can get very overwhelming for folks to think about. So, I always encourage folks, if you're looking for yourself or for a family member, an elderly parent of some kind, start early, start looking at facilities, asking questions. That's really the best way to learn, what's available out there and how it's paid for and what you get for your money. There's a wide variety of what you get. And there are definitely going to be facilities out there that you would not want you to be in, or your parents to be in, or a loved one to be in. And there are others that are. And knowing a little bit more about that will make you better equipped to do some planning in advance to make sure that you can afford to pay that. So okay. Well, that's what I have available for you tonight. I thank you again for joining me. Appreciate your support for our webinar series. You can subscribe to us on Eventbrite. We do have a page on Eventbrite. You'll get automatic notices every time we post a webinar to our Eventbrite page, and you can sign up. And please share them with your friends, your colleagues, your customers. We would love to have them join us for any one of the webinars that we have coming up here in March and beginning of April. So thank you and have a great night. Take care.